5. This is HOA Today. HOA Today is brought to you by Zayuk. Zayuk is a company that provides smart property software and smart property inspections to provide HOAs and condo associations a platform to store and interpret the data that they are receiving. It works in real time through voting, through governance such as rules and asset ledgers, and then our reserves inspection, which is an annual inspections that are required by HOAs, is provided through our platform. So if you live in an HOA, if you're a board member, if you're a manager, we give your property the opportunity to store their information, maintain their information more effectively. So in HOA Today, we usually go through current events and various items within the HOA space. So one new item in California. This happened about 3 months ago. Assembly Bill 130 put a cap on fines in California, led by Democratic Assembly member Buffy Wicks of Oakland. Language spoke of a separate bill by Democratic Senator Aisha Wahab of Fremont. Senate Bill 681 capping the HOA fee was included in the housing reform bill just days before the governor signed it into law. And we've spoken about various instances here on this live stream where HOAs do fine to a point that becomes very damaging to certain residents. New law caps fines at $100, down from hundreds to thousands of dollars. This is amid an affordability crisis, so it's understandable when housing has skyrocketed, HOA insurance has skyrocketed, and general inflation has occurred higher than normal in the last 5.5 years in a way that has affected construction maintenance that HOAs have to deal with as well. As in another part of that is there is deferred maintenance on several buildings throughout the country. We are getting to a point where much of our infrastructure was built 40, 50, 60 years ago, and EOL end of life occurs in that time frame for many of these items. And if there hasn't been proper maintenance, then that degradation occurs over decades, and recuperating that or rehabilitating that is expensive the longer it's put off. HOAs are proliferating nationwide. 67% of all new single-family homes built in 2024 nationwide were in communities with HOAs. It is, I've heard, an easier route for builders to. I would love to get a builder on and speak about this, but based off of what I've interpreted, that HOAs are a preferred platform for developers, and in that it's simpler for them to go through the process than to say not have an HOA. And as long as homeowner associations are run correctly, which is not easy, and that's why there's so many problems with them, it requires constant communication, constant output, and having a skilled manager is important. It's not a easy thing, but it's really important and can affect your HOA significantly. California, more than 50,000 HOAs. Also having a platform like Zayuk. I don't think Zayuk is. I don't think we have a comparable solution with our reserves inspection system where we actually combine your daily software with the reserve system that you use, give you an integrated asset ledger that allows you to maintain record of governance, of assets, and it's very powerful. California, more than 50,000 HOAs, govern 65% of states' homeowners, paid a median of $278 in monthly fees, among the steepest in the nation. Create and enforce rules for homes, apartment, and condominium owners, and are controlled by residents themselves who elect and recall board members. Have faced ire and frustration of Californians for decades. Lawmakers have proposed legislation seeking more transparency on governing boards, and Zayik provides that layer of transparency that the state governments across the nation, whether that be California, whether that be Utah, whether that be Florida, Georgia, Minnesota, states that do have widespread use of HOAs. Zayik provides that layer of transparency, and we provide that on behalf of managers or an association. So if you're an association, reach out to us and we can onboard you. We'll migrate your data as well into our platform. And you can use our platform to manage your vendors and give them a platform to store your data, because it's more important than anything else to have a platform where you can invite vendors and they can store your data. And we give vendors a platform where they can actually maintain multiple properties themselves. But again, HOAs, our system is fine tuned for owners of homeowners associations. Okay. This was a fairly large story that came out yesterday about a mom charged $382 for an issue. We'll dive into it. Okay. Orlando. And this comes on the heels of what we've spoken about. There's already, I don't want to say a move, it might be a movement. March on Capitol Hill to protest. So this came out last month. Homeowners schedule a march on Capitol Hill to protest Florida's HOAs. And HOA labeled her son, quote unquote, a public nuisance. 5-year-old son charged $382 after allegedly her son was targeted for swinging on a tree near a bus stop. And this comes as a University Pines Property Owners Association, children swinging from tree branches and throwing rocks, hyper in the mornings, quote, everyone is happy, unquote. Son labeled a public nuisance and annoyance to the neighborhood, told to pay $380 to cover the attorney fees associated with drafting the letter. And this is in Florida and in California, as we just mentioned, by AB 130, that actually would not be permitted to fine more than $100. Yet, and there's no threat of litigation against the homeowner. Homeowner disputes the claim. Okay. And as I mentioned, this is on the heels of a homeowner schedule a march on Capitol Hill to protest Florida HOAs. And Florida had a very difficult last 3 to 4 years. I would say 4 to 5 years. Again, they've had all these issues that we spoke about, which is, well, we did speak about insurance, but we also spoke about inflation, how that affects construction, various things. But they also had a construction collapse that killed nearly 100 people 4 years ago, and that set off legislation by the government that stressed out many Floridians. And on top of that, Florida has had an insidious weather patterns. I believe this year was the first year a hurricane didn't land uh, in the area in like 10 years. I believe I heard that. Don't quote me on that. And I'm not saying in Florida, but on the East Coast, I believe the mainland. And so you have these hurricanes, high wind, high moisture systems that run through that state. And you have many sky rises. You have many buildings that are reaching an EOL, end of life cycle. You combine that with the government possibly recognizing that too late on the heels of a tragedy, and then putting in legislation that was, I've said this before, correct in some sense, but on the cycle to implement it, nearly impossible. Not nearly impossible for all units, but there were some units that some associations that had a very difficult time, that were underfunded for several years, several decades. And again, you talk about seaside skyscrapers. I'm sorry, not skyscrapers necessarily, but just seaside high rises. These become systems that degrade easily. And that's why Florida has now required inspections, and they require certain laws, three for stories, 3 stories and up. And our system works very effectively when Floridian HOAs and Floridian condo owners would be remiss to reach out to Zayuk and ask for our inspection system and integrated platform, because that state, with the requirements coming out, with the number of high rise, seaside, or high humidity location, we have platforms and reserves inspection services that are not mimicable in the moment, and it integrates with your daily software use, your daily operational set. And so I'll return to what I was speaking about. But again, March on Capitol, I'm wondering when this is. I might reach out to this individual. I mean, it's tough because this state is not an easy state to handle when it comes to HOA. They also have one of the highest implementations of HOAs, as well as many 55 up senior communities. It's just a litany. And that's why in Orlando and Florida, it's these systems, these HOA systems are a big deal. Okay, we'll move on. Colorado. Following a recent protest in Colorado Springs by members of an HOA over a special assessment of more than $10,000 over the cap stated in the declaration, News 5 wanted to know what other ways HOA members can take action and get information. The HOA Center was created in Colorado back in 2012 to help Colorado consumers with understanding their basic rights under the Colorado Common Interest Ownership Act, CCIOA. Help individuals, not allowed to provide legal advice, and nothing that I say is legal advice, and I'm not a lawyer, and at no point should you reference me for any legal advice because I'm not a lawyer. We provide software that provides governance items and actually gives you a place to invite your lawyer. So you can invite your lawyer to check out your work orders, to check out your governance issues. You can bring your lawyer onto the platform and give them an area where they can see these items as well, and they can see the state of your property. But none of this is legal advice. Although Zayuk, none of this is legal advice. I'm not a lawyer. Zayuk provides modules for governance, for voting, and we take governance and as a pillar. It's really important. And I speak about this when I speak about how people should look into purchasing in homeowner associations. 3 pillars: asset hygiene, financial hygiene, and governance. Asset hygiene is fairly simple to understand. Is the home being upkept? Is the property being upkept? And you may look at it and say, well, I just care about my one place. Well, you're a partial owner of that property. So you actually care about the entire system because you're liable for its maintenance at that point, and set a set of governance rules that you're going to be held accountable to as an owner. So if you are going to reside on that property, again, I said the 3rd pillar is governance. Really important to understand what rules you're going to have to live under. When you're a tenant, I believe it seems people are less apprehensive to certain governance items. Like, okay, I don't own this. This is your property. I'm here as a tenant. I'm not the landlord. When people own into that property and they're told that they're not allowed to live in this certain fashion, it is distressing for people. You're being told on a place you purchase you can't live in accordance with this certain habit, function, way of life that you're attempting to act on. It becomes deeply distressing for people. So it's important to understand when you purchase, when you make this investment into your home, what is the governance? What rules am I going to have to live by if I live here and own here? And in order to join the association, you have to agree to abide by these rules, legally abide by these rules. And that's unavoidable. So it's important to understand what obligations you're going to be held to. And again, none of this is legal advice, and I'm not a lawyer. If you are really concerned or really want to be careful, reach out to an HOA lawyer. If you live in a major metropolitan, likely one in the US, likely one in your area that can tell you the ways to consider this in your local ordinance or your state. Okay. So, and then I said governance and asset hygiene. And I'm going to say financial hygiene a little bit later. We'll move on with this Colorado. Excuse me. So you can find the HOA Center at dre.colorado.gov/HOA-center. And you can check out Common Interest Ownership Act, relevance and applicability of the Colorado Common Interest Ownership Act. And that's what this is about. It's about owning. It's about living where you own, but also owning. It's very important. The best run HOAs have in common. Okay, I'm going to save that for a moment. I'll probably go through this Colorado piece later and check it out. Seems pretty interesting. Okay. Through the HOA Center, the public can file a complaint, register their HOA, and get frequently asked questions answered, among other things. Collaborate and collect all of that information from all these complaints. create resource materials, provides education and forum, provides a website with information for the public, registers HOA pursuant to 38 TAC 33.3 TAC 4011 CRS, and provides annual report. Okay. And here's another article that states Coloradans are very low on the HOA fees. They have a median of $99. I don't know where that necessarily ranks because of this graphic, but one thing I noticed is Hawaii, New York, and DC are huge. New York at 739, DC at 505, Hawaii at 470, and New York has very particular co-op laws, and so their state has a unique situation as well. And then some close runners: Rhode Island, Massachusetts, Connecticut, New Jersey, New Hampshire, Minnesota, Illinois, Florida, California, all over 230 or higher. And the ones in New England are over 300. It's a deeply widespread system. And there's a lot of changes, and there's a lot of changes in many industries, but this one as well. Oh, excuse me. Okay. So okay, we have a few more, and then we will move on. Oh, wow. This is a pretty extreme event. And it speaks about mental health at the beginning against a man accused of opening fire at landscapers and police in the North Kentucky suburb. Pleaded not guilty to numerous charges, including attempted murder, criminal mischief, assault, and harassment. Held at Hamilton County Justice Center, extradited to Kentucky on September 10th. $100 million bond. Evaluated for competency and criminal responsibility. Forensic psychiatric hospital adjacent to a state prison. June 12th, standoff at the Triple Crown neighborhood of Union, preceded by an incident involving a landscaper just 3 weeks earlier. Reported that the homeowner had assaulted the landscaper. Hired to perform work on the lawn of the homeowner, out of compliance with their standards. Someone would be sent to cut the grass. Bullets began striking the landscaper's vehicle. This is very unfortunate and kind of one of the more insidious aspects of living with many people, is that you may have an issue like this where there's someone with some pretty extreme mental health issues, and it becomes a danger. Becomes a danger, and it's really unfortunate. It's part of life, unfortunately. And when you live in a high density environment, that likely has a higher probability of HOA, but even single family homes, it's understandable. I mean, it's not understandable or acceptable, but it's going to happen. High probability. Okay, we'll move on. Okay. Yes. CurrentFederalTaxDevelopments.com has released a blog, Tax Exemption Denial for a Gated Community HOA by the Tax Court. Mira Vista Homeowners Association Incorporated versus Commissioner of Internal Revenue addressed a homeowner association's denial of tax-exempt status under IRC 501c4. The petitioner, Mira Vista Homeowners Association Incorporated, sought a declaration that the commissioner's final adverse determination issued on April 6, 2022 was erroneous. Organized as a nonprofit corporation under Texas law on March 25, 1988, operates within the Mira Vista development, a gated community in Fort Worth, Texas, comprising approximately 700 acres, 657 single-family homes, and 2,000 residents. That's a lot. Governing, improving, operating, and maintaining common areas, 96 acres of green belts and sloping fences, 25 miles of privately maintained streets, nature trails, and a recreational facility featuring a lake, restrooms, a fishing dock, a playground, and a picnic area. Membership is mandatory for all homeowners within the development. Claimed that its activities lessen the burden of government through code enforcement, private security, maintenance of infrastructure, operating a 24-hour guard post facility, and cooperating with local government regarding services like water usage, garbage, and recycling, street maintenance. This is a really interesting, just before we even continue, that whole concept of taxing versus maintenance, because you have, I mean, that's something that we've spoken about in Illinois. You have it in Hawaii where there is maintenance, and it does the responsibility, but also not just the responsibility, the repercussions of your risk being executed just by the factor of the life cycle, it just happens. Usually the more local ordinance is going to be affected, so the HOA will be affected more than the city, because the HOA, it's something like the Palisades fire. The local community was devastated, whereas the city of Los Angeles as a whole had about a week of intense skylines and fires and evacuations, but I mean, most of the city did not go on fire. The Palisades community and the surrounding area was torched, and that place had devastating impact. So it's interesting to consider this Fort Worth community, Mira Vista, stating that they might have okay, so we'll continue to determine what they're actually asking for. December 12, 2019, association submitted an application to the IRS seeking recognition as a tax-exempt organization under IRC 501c4. And they're generally exempt from federal income tax under 501a, while the association presumably elected and qualified for the preferable tax status under 528. taxation only, or non-exempt function income. Qualification as a social welfare organization under 501c4. Was denied February 2, 2021, stating association did not qualify for exemption because it did not benefit the community on an unrestricted basis, limiting benefits to those within the gated community. That makes sense to me. A CPA acting on behalf of the association, Gary Porter, protested this conclusion, arguing that the association's activities qualified as a social welfare organization. He also contended that the other gated homeowners associations in Texas had been recognized by the IRS as 501c4 organizations. Contended that the other gated homeowners association in Texas had been recognized by the IRS as 501c4 organizations, issued a final adverse determination on April 6th. The association did not promote social welfare or provide a community benefit because it did not allow public access. Association filed a petition seeking a declaration that the IRS's determination was in error for the matters confirmed IRC 7428A1. Okay, this is going to get pretty deep, guys. Deposition of the declaratory judgment is ordinarily based on the stipulated administrative record, Rule 217A. Scope of review is limited to the propriety of the reasons given by the commissioner for denying the exemption. This is some this is some quote unquote legalese for sure. The taxpayer bears the burden of proving the commissioner's determination is incorrect. Again, none of this is legal advice, and I'm not a lawyer. And if you have questions or issues regarding HOA law, certainly go to a lawyer, preferably in the ordinance that you are asking those questions for, because I'm not a lawyer and none of this is legal advice. But this is a really interesting blog. And as someone who's in this is very complex, but it's very interesting. Consistent legal conclusion reached by the Fifth Circuit and other courts of appeals is that an organization operating primarily for the benefit of its members rather than for the community as a whole does not qualify under 501c4. Stress that an organization that provides substantial benefits to private members alongside the public is not primarily devoted to the common good. Does not serve a community within the broader social welfare context. The association conceded that it was, quote, not a community in and of itself, argued that public benefit rather than public access should be the determining factor. General public receive benefits through its facilities, fishing lake, dock, playground, and services. But the court concluded that the association failed to meet its burden. And the benefits were, quote, merely incidental, primarily for the benefit of its members, and are generally inaccessible to the public. The gates, in accordance with the association's governing documents, the gates are open only for members, residents, and their guests, with the sole exception being the charitable events hosted by the unrelated country club. The association's facilities are not a part of those permitted entries, nor intended for those events. And the court determined that the benefits derived from the association's private security patrols, code enforcement, road maintenance, and cooperation with local government were principally undertaken for the benefit of its members and guests, offering only an incidental public benefit. Therefore, The court found the association's facilities are maintained for the benefit of its members and not used by the public. Yes. And going back to what I mentioned before, it was very different. I was actually speaking about incidents that occur mainly on shared ground, but the consequences of allowing things to persist, like dry brush in your surrounding area, overgrowth in your surrounding area, it may be the city's responsibility, and communicating with your local ordinance is important, but the consequences will fall on the local property. Okay. Well, thank you, everyone. Thank you for joining me. Hopefully, you all have a great Thursday ahead, and